Lords, I get the impression that there's a bit of a misunderstanding about the nature of employment tribunals. I spent the first half of a very long career at the bar doing employment tribunal cases, many of them unfair dismissal cases. In fact, the first case I ever did was in 1972, pro bono, by the way, an unfair dismissal case under what was then the very new unfair dismissal legislation. Unfair dismissal cases are very difficult for employees to win. Most cases that go to a full hearing on unfair dismissal result in the employer being vindicated. But there's 2 points I want to make. The first is that employment tribunals now have got very robust procedures for weeding out vexatious cases. Vexatious cases never go to a full hearing. The second point is this, just to remind your lordships of the law on unfair dismissal. It's section 98 of the Employment Rights Act of 1996. The employer has to, the test is in 2 parts. First, the employer got to demonstrate that the reason for the dismissal is capability or qualifications or conduct or redundancy, or that the employment is in breach of some enactment. Once the employer's shown that that is the reason, the test then for the tribunal, and I'll read it out, as to whether or not the dismissal is fair, is this. It depends on whether, in the circumstances, including the size and administrative resources of the employer's undertaking, the employer acted reasonably or unreasonably in treating that reason as a sufficient reason for dismissing the employee. So all the factors that one would expect to have to be taken into consideration are taken into consideration. And then the tribunal has to determine that in accordance with equity and the substantial merits of the case. But the Court of Appeal have added yet another burden. When the tribunal decide whether the employer acted reasonably or unreasonably, it's not what they consider was reasonable or unreasonable. It's what a band of they consider whether the dismissal fell within the band of responses of reasonable employers. So it's at 2 stages removed. It's not like an ordinary negligence case where the court decides whether the employer was reasonable or not reasonable or putting the guard on the machine. They have to decide, even if they think that the decision was unreasonable, if they find that it, nevertheless, reasonable employers would say that it might be possible that the reason was fair, that would be legitimate. I'm so sorry.
The Noble Lord Hendy referred to the likelihood of cases succeeding if they got as far as the tribunal. Will the Noble Lord accept that the vast majority of cases that are initiated never get as far as the tribunal? And that is because there is a huge incentive in the system for employers to settle. The costs of taking a case right the way through are huge, and not just in the monetary cost of employing clever employment lawyers, but in particular the diversion of management effort within the organisation. And I've seen this particularly in large organisations where swathes of the management team can be tied up for very long periods of time. Employers can't afford that in the broadest sense. If you then put that in the context of a smaller organisation, they absolutely can't cope with it. So whatever happens at the tribunal, whatever the law says, the mere initiation of an action nearly always results in the economic decision made by the employer to settle. And that is one of the most difficult aspects, and why extending that into the early period of employment causes so much trouble, or so many worries for employers.
I absolutely agree that most cases never get to a full hearing. It's only a tiny minority that ever do. And the noble lady is right. Many cases settle, of course. Many are conciliated because there's now compulsory conciliation by ACAS, but many are withdrawn by the employee. And you've got to visualise, of course, the noble lady does, but most employees bringing an unfair dismissal claim are completely unrepresented. They're on their own. So all the expense and research and preparation that's got to be done has got to be done by them personally. And that's a huge disincentive. Many, many claims, thousands, tens of thousands of claims are simply not brought. It's not worth the employees' while to do it. And that, of course, is particular.
The Lord accept that is exactly the same case for small employers, that they too will be in the same position of having to deal with tribunals in the same way, and hence why often as not the settlements are taking place.
So of course that's always the way whenever there's litigation over whatever the subject matter is. People don't want the burden of defending the case. People bringing the case don't want the burden of bringing it either. I mean, that's just the reality of litigation. But I say one last thing before I sit down, and that's this, that the argument that the noble lords and ladies opposite have put forward is all about what they perceive to be the consequences of this, a matter that my noble friend Lord Monks has just addressed. But nobody can seriously advance the case that employers should have the right to dismiss anybody unfairly without recourse to the law.
Dan, would you accept that these are not arguments simply that people around this chamber are putting forward? These are actually in the impact assessment of the bill. This is the government's own statement that it will have these impacts. It's not being made up by any of us. The government accepts that that will be the impact.
That may very well be, but it still doesn't remove the fundamental point that what's being proposed is a category of worker who can be dismissed unfairly for the most extreme reasons, but without resort to any justice.